unequivocally need a will if you are responsible for somebody else. That's the most important part. It doesn't matter what your net worth is. You need to leave a set of instructions. Otherwise, you leave a set of headaches, a set of migraines you leave to somebody else. A will. If you have children, non-negotiable, do it.
If I'm on a ventilator, like, do I want to live? Those kind of things. Don't leave that decision for your children to make. Our role as fathers in particular is to fall on every single sword on behalf of our children.
My biggest fear in life isn't dying. It's
All right. Hey, welcome back to Remnant Finance, everybody. We've got a repeat guest here, our second of hopefully many more to come. We've got Ro from the Owner's Asset. Welcome back, Ro.
good to see you, Hans.
Yeah, that's quickly becoming one of our most popular episodes. And I'm not a big LinkedIn guy. I know you are. I know that's your primary wheelhouse because your clients are mostly, almost exclusively business owners. And so when I look at LinkedIn, it's basically just financial advisors selling their services to other financial advisors is how it comes across to me. But I found that is gaining a lot of traction, that episode, and there's a lot of discussion. There's a lot of engagement with that, at least compared to me, which I don't engage or really check it, but just because that is where we're mainly focusing that episode. It's gotten a lot of attention from advisors and from business owners. So it's a really fascinating concept that I'm still really excited to keep exploring, both for Remnant Finance, for Brian and myself, as well as for our clients with businesses. And our general flow of conversations here, if you haven't listened 2 weeks ago, we had a 2-hour plus discussion kind of deep diving on what is a cash balance plan. It's a type of retirement plan that we can fund with life insurance and get deductions on the front end. It's a brilliant strategy for the right business owner with a tax problem, which is most business owners. The other conversations we want to talk estate planning today, more of a higher level overview of estate planning. And then we want to do a couple episodes on case specific types of clients. And I've got a few kind of avatars that we'll talk through, which are either friends or clients in their specific situations, but they sort of group into, the small LLC, someone who's got their primary W-2 income, but is doing something on the side to generate income. And how can they possibly use this strategy, all the way up to the high net worth individual who has a large tax problem. But anyways, let's start with the basics of estate planning. Ro, what's the general kind of flow of what you want to cover today when we talk through this?
Yeah, no exact. I want to keep it high level because the first rule of estate planning is each estate plan is as unique as everybody's own fingerprint, right? Mm-hmm. What works for me will not probably work for some of my clients and won't work for my ultra high net worth clients and will work for someone else. So that's the first rule. Is everyone thinks there's some magic bullet when it comes to estate planning. If there is one, maybe we'll get to it at the end because there is one or two really cool techniques that involve life insurance, which is where I want to end up. But along the path, Hans, there isn't something that works for everybody. It's a combination of things. So that's the first caveat, is the flow. And I think the right place to start, and I know you're studying for the CLU, so you probably know more about this than me. Right? Yeah, the first place to start is, well, there you go. Oh, great. So I'm up against the textbook. I appreciate that. The first place to start is let's just define some terms. Let's get some definitions on the table, and what are the most important 4 documents you need? Do you want to start there, Hans?
Yeah, let's do that. Let me just read this first 2 sentences. In the estate planning textbook, what is estate planning? Estate planning is broadly defined as the process of accumulation, management, conservation, and transfer of wealth during legal, tax, considering legal, tax, and personal objectives. It's defined as the anticipation of the person's inevitable death. The goals of estate planning are effective and efficient transfer of assets. Effective meaning, do you get the assets to the right person? Efficiently meaning, do you minimize the costs, and particularly the taxes being the largest cost there. So that's a pretty broad strokes overview, but we're trying to manage the accumulation. Check. Most of us are familiar with that. That's what we focus on when we're talking about financial planning. The management, the conservation, those 3 are while we're alive, and then the transfer piece. And so the thing to point out is estate planning is not just get some ducks lined up in a row so that when you pass, things go through the right flow chart to get to the right people. Like estate planning happens now while you're alive, correct?
It starts while you're alive. It does. there really is one major fork in the road with estate planning is your net worth above or below the estate threshold, which is currently 30 million for a married couple, 15 million per person. So if you're below that, yeah, then it is relatively straightforward, but that doesn't mean it's not unique. Just because it's straightforward doesn't mean it's bespoke to you. And so that's where we're going to start. So the first document that I think everybody needs to have and should have, and I read up on this, is it's estimated that 52% of Americans don't have the first document. And that first document is a will. It's a last will and testament is typically the first document. So do we want to define that first and then go to the pros and cons? Okay. So you define the last will, and I'll talk about the pros and cons.
Yeah. So if you don't have a plan for what is going to happen with everything you own when you die, just think if you wake up tomorrow, and this is an exercise I like to play with a lot of clients, you don't wake up tomorrow, go. What's going where? Is everything going to your wife? How is that being transferred? Or particularly if you're the last spouse to die, how does that get past the next generation? So the will is going to define a lot of those things in a fairly clunky manner.
Exactly right. The big four documents, and the first of which is a will, these are your flight manuals. I'm trying to come up with pilot analogies, and I spent a little time in my walk this morning being like, I got to make this relevant for Hans's audience. This is one of your flight manuals, right? This is going to be the catch-all. What this is an instruction set for all your assets that aren't held in the second document. Okay, so this is an instruction manual. Let's talk about the pros and cons. You can literally, in your will, which can be handwritten, it's allowed to be done. I think the term is holographically, right?
Holographic.
Yeah, it can be done holographically. And in 46 or 47 of the 50 states, you don't even need a witness. So literally, you can just write it down, and I'm of sound mind, and I leave this there. So what does it do? It gives a set of instructions, right? It's your flight manual. It gives a set of instructions to your heirs about what you wish to have happen. Where it shines, its number one use is that it is a document to name guardians for your kids, or if you are the guardian of someone else, they would take that over. That's huge. I want to spend a minute here because a trust cannot name guardians. That is huge. So anybody with children say, I just need a trust. No. If you have kids, the will is where you put that. And I interact with a lot of trust and estate attorneys, and most of them don't even use wills anymore. And if you're not responsible for anybody, don't have kids, don't have a parent living with you who you've taken legal guardianship over, you may not even need a will, but you unequivocally need a will if you are responsible for somebody else. That's the most important part. Sorry, Hans, go ahead.
No, that's great. And I think focusing on the non-financial aspects of this is really important. It is one of the overlooked things. And so if you heard Ro say that the estate tax threshold at the beginning is $30 million for a married couple, and you think I'm nowhere near that, so this doesn't apply to me, well, don't tune out yet. Because one, if you're a client of ours and you have a large whole life policy and then some term on top of that, that is going to count towards that $15 million limit as long as you own that policy, i.e. it's not an irrevocable trust. We'll get to that later. If you live 50 or if you live, say, 30, 40 more years with the policy structured the way that we designed them for IBC, and then you have this complement of convertible term as well, you might find yourself in that situation where you're coming up on that limit just by your life insurance alone, or that might get you a large part of the way there. So don't write yourself off yet. And one of our goals, like at Remnant Finance, is I want you to have an estate tax problem, because that means you have a large amount of money that you need to figure. It's a headache to deal with estate tax. It's a very complicated world, but I want you to have that problem, because more money, like having that problem means you have that much in net worth to pass on to the next generation. So that's one
That
thing.
is such a good point. I jumped the gun. You're right. Estate tax and estate planning are two different ideas. Estate tax is what happens when you have more than 30, but everyone in America has an estate planning opportunity or estate planning need. Sorry, well said. You got to slow me down and back me up because I get in the weeds quick, Hans. You're exactly right. If you don't have these documents, someone else is going to decide what happens to your stuff. Whether your stuff is your primary residence, your watch collection, your stamp collection, your kids. I mean, kids are stuff in the eyes of these documents, right? And so you're exactly right. Doesn't matter what your net worth is. You need to leave a set of instructions. Otherwise, you leave a set of headaches, a set of migraines you leave to somebody else. So great clarification. I don't even want to talk about the estate tax until the very end if we build to that. So let's focus on estate planning. Okay, so the will. It's your North Star, it's your manual. Two, it is the most essential document to see who takes over the kids. Third, and this is really important, I call it the catch-all. If anything is not explicitly named somewhere else, the will usually catches it. So for example, this is going to get a little nuanced, but anything where there's proof of ownership usually goes in the trust. This is how I think about it. It's not exact, but anything where there's proof of ownership, what the heck does that mean? Why is this guy talking about using big finance words? When you buy a car, do you have to have a title?
Yep.
Okay. When you buy a watch, do you have to have a title?
No.
There you go. When you buy a house, do you get a deed and a title?
Yep.
If you collect baseball cards, do you get titles for those?
Nope.
There you go. That's how I think about this. Is if you have stuff that's not have a proof of who owns it, who bought it, and all that, that stuff usually gets caught and put into a will.
Okay.
So, like, if I have a watch, and it's really interesting for military families, for your audience, there are family heirlooms passed through this rich military history that your audience has, Hans. Whether it's medals and acts and honors of valor that are in your world. If you have a few kids, they may, unless it's explicitly stated in the will, they could fight about it, right? There could be dissension over who gets that, right?
Right.
And so really important, because there's not a deed or a title to that act, that accolade. So it's really important to have a will for the kids and for the stuff that's not titled.
Now, real quick on that, and this is jumping ahead briefly, but just because I've been going through this project, I was going to call it Trust Day, and I'm building out my plan for Trust Day, and I'm working with Claude to get everything squared away. Like, what all documents do I need? I want to redo, or I want to get a fresh look at everything. You know, I've sold a truck since then. Let me just all this stuff. I've had a kid since I last did it. So let me just do a comprehensive Trust Day has become Trust Month, which is now by the end of 2026. I want to get this like revised and updated because it's a lengthy process. You know, getting the rental properties into an LLC, the LLC funded, and all this stuff. But this in the trust, the specific bequeathments or specific bequests, is that the?
I think so.
But stuff like that, like I have in there in the trust. Now, this might be because this software that we use particularly has an area like a last will and testament section, but also these specific, I'm going to say bequests. I can't remember if that's actually the right word, but that's where I've said things like these, you know, like my wife's engagement ring and wedding ring goes to our older daughter. And then this other jewelry that she has goes to the younger daughter. Like we have to make those delineations there. So can we still do this in a trust? A lot of our clients use the same company that
software.
We use.
Yeah. Yeah, it is bequests, and yes, you should put them in their trust. But if there's something you forget about, because we'll get to trust and we'll time you back to the rings in a second. Let's finish the cons of a will. So we did the pros of a will, right? Simple, cheap, affordable, catch all, make sure your kids are taken care of. Cool?
Yep.
Cool. The cons, and there's some big cons to wills, and they're worth. People think, oh, I got a will, I'm covered. Wills are a matter of public record. Your dirty laundry and what you own is written in a document, and it is a matter of public record. So if you were one of those miserly folks who, you know, lived, I love those kind of people who live below their means, but you did have a couple of really nice things, and you didn't title them to your trust, like the ring, right? And it wasn't formally written in the trust, but it was in the will that my personal effects will go to this or that person. A list of those personal effects will become public. My 7 Rolexes, the 6 cars vintage cars I collected that I didn't move the title to the trust, right? So that's the first, is it is a matter of public record. And that's a huge issue because privacy is very important, very valuable to a lot of people. I think the famous case that really reminded folks how important a will is when Robin Williams passed, right? The famous comedian. It all became a matter of public record. Wills have to go through probate. That's the biggie. I mean, wills go through probate. Probate is the process by which a court decides, does this will stand up? And it's usually pre-approved, and you get what's called, I think, testamentary approval. I forget the exact term for it. But yeah, wills go through probate. And third, wills can be contested. A hostile party can come in and say, well, when I was with Hans as a senior in college, he promised me his his vintage helicopter collection of this and that. And someone can contest it. All that can happen in a will. So those are the cons.
So and think like the first thing that came to mind when you said that, when I was in college, like had say Mark Zuckerberg died shortly after starting Facebook, and then there was the challenge of like, hey, we had this group project, right? What is it, the Winklevoss twins?
No
That,
Winklevoss twins, yeah.
and I don't know, I don't know if it, whatever, but they make the claim, and they could have come in and said, hey, we are entitled to 2/3 of Facebook because we created with him. There's nothing in the will and trust. I'm looking in the textbook right now, and they have examples of famous people and their wills, and there's like 4 pages of fine print of Elvis Presley's will, right? There's probably about 25, maybe 30 different items on there, and it says that he put together a pretty comprehensive will, and the net effect was that he passed 27% of his wealth to his heirs. 27%. And this chart here goes down the list. Like Walt Disney, $23 million estate, taxes and costs were 6.8. He ended up passing 7%. Sorry, 70%. A lot of names that you'd recognize on here. John D. Rockefeller, $26.9 million. He passed 36%. And so there's examples here. There's the last will and testament of Supreme Court Justice Warren Burger. You can see it's about that big. It's that little box there. And he passed 98%. That was effective. Elvis Presley's is about 4 or 5 pages of that, and he passed 27%. And so this is one of those areas where there's so much to know. Just like I don't think you should be doing your own taxes if you have anything more than just a W-2. Like, this is a very detailed and complex area where you want to work with someone like Ro, someone who knows this field inside and out. Because if you have this, I mean, it even says like this is a very good will that Elvis Presley left, and it got 27% of his wealth to his heirs. And so, and that public element comes out whenever there is a celebrity that passes, and there's these long drawn out fights over their estates, and any blood relative can challenge the will, right, in court.
Yeah, absolutely. A plumber who could take a first lien on something could, because you didn't pay him, or you paid him $10 less and they were pissed, right? So quick bow tie on the will, and then we'll move on to the trust. A will, if you have children, non-negotiable, do it. End of story. You cannot name guardianship of children, nieces or nephews you're responsible for. Have to have a will. Non-negotiable. Stuff you own that you want to direct where it goes that doesn't have a clean ownership, like again, a car, you get a title, a house, you get a title, and you got a watch collection stand, you want to adjudicate, you want to help decide where it goes, that goes in the will. Cool. Cons, public, can be contested. We nailed it. That's a will. So if you don't have kids, please.
One distinction to make here is your probatable estate and non-probatable estate. And so it's not just that someone can contest it, it's that it goes to court in the first place, and the probate court is a feeding frenzy for lawyers and for the state as well, right? And so that's where a lot of these costs come out. And so your corpus is not going to survive intact going through that process, even if it's airtight, because of the cost of going through probate. And so that's one major element there. You're going to be like trying to get money through a sieve, like it's just going to be so porous when it goes through that probate process. So even if no one challenges it, you have time delays. One quick story here. We did an episode on estate planning maybe a year ago at this point, but it was kind of at a more basic level than I think we're going to get to today. But Brian, when his mom passed, left everything to the children, no disputes. It was clean. No one challenged the will. It took over a year before they were allowed to sell their house. It took about 6 months for them to be able to do anything at all.
Right.
And so the only thing that passed quickly and instantly was something out of the out of the probatable estate, which even if you don't have a trust in place, the life insurance, it's not a probatable asset. It's a trust asset, or it's a titled asset.
It has a distinct beneficiary is the way we need to think about it. I don't want, I know the legal terms. I refuse to go there because whether you have 50 grand or 50 million, you're looking for simplicity and clarity here. And so a will adds that, right? And that's the next fork, is a trust. What role does that play? So let's go to trusts. So the second doc, so doc 1 of your flight manual is your will. Doc 2 is a revocable trust, okay? So a revocable trust is literally just a piece of paper drafted by an attorney, signed, but a piece of paper that dictates exactly what you want to have happen with anything and everything you put in there. It is much, much more powerful than a will.
So what's the difference here? If we're just putting, so if my house goes through probate versus because it's in my will. I leave my will to my children, or my house to my children in my will, versus I leave my house to my children in my trust. What's the difference?
Huge difference. Well said. It skips probate. So if you leave it in your will, and the court has to approve the transfer of that deed of title of the house, the court has to approve it during the probate process. If it is stipulated in your trust that the house moves to the kids, it completely is removed from that legal step. It moves at the speed of a signature. I'm sort of trying to come up with terms, right? It moves as fast as you signed it that day, right? We'll get to the cons because the big cons, and the cons are actually human, not legal. The legal power of a trust is phenomenal. But yeah, that's exactly right, Hans. If you want something to pass to whom you want and done efficiently and quickly, you put it in your trust. If you say, my kids have been fighting about this for 20 years, I'm not going to do it, let the courts decide, put it in their own, watch your family implode, right? The trust skips that process. Great question, Hans.
Mm-hmm. Yeah, because you could specifically say, you know, for instance, let's say you have life insurance and you have the trust as your contingent beneficiary. Your spouse is the primary, your trust is the contingent beneficiary. And let's say your spouse predeceases you, so when you pass, it goes to the trust. Those funds go to the trust. Well, in a life insurance beneficiary structure, you can name individuals, or you can name a class of individuals. You could say spread among all of my children and future children, right? You could say spread among all of my grandchildren, or you can define a class of individuals that you can split them amongst, or a tier like a primary contingent beneficiary. But you have some control over that, but you don't have as much specific control. So for instance, if the trust receives those funds, then you could say 10% is going to go to this charity, 20% is going to go to every child for these 3 children, and the rest is going to be divided up between educational ventures. When they you have much more fine-tuned control on the distribution in a trust, because you can basically just choose your own. Like you could write a thesis on how everything's going to get distributed if you want, because it's up to you. And it's going to go according to the will, to that document.
Exactly. The kids only get it if they graduated from college with a certain GPA, only if they have a great dental record. It is your way to control that word IBCers love, right? Control and
Dental record.
sovereignty. It is what you can make it up. That's the point, right? I had a client. It wasn't my client, but the Wilmington Trust, when I used to work there, so they left money to a cat, and that was just a nightmare. Ultra wealthy people do crazy things with money. But yes, okay. So the second benefit of a trust is the privacy, and this is probably we mentioned that a will is public. You had shared the stuff about Elvis. Trusts are completely private. You can even name the trust something that no one would guess is yours, right? So it's privacy is very important, and whether that's because you want to keep the types of assets, private businesses, out of the public scrutiny, or just that's the way the family operates. And so privacy is the second biggest aspect of a trust, Hans.
Now there's very obvious, and I would imagine fairly well-known benefits of having a trust. But if you were to go on, TikTok and look up trust, like you can find so many sensationalized, usages of a trust as it's laid out. You could quickly think that the trust is just this magic bullet. And you might think that by putting these assets in a trust, they're untouchable. Like nobody can sue me and get to these assets because they're removed from me. I'm improving the taxation, et cetera. And can you dismantle or shatter those illusions that often come with what we're pitched as the benefits of a revocable trust?
Well said. And that was one of the cons I had on the list. But yeah, let's just go there. A revocable living trust is not creditor protected. Period. End of story. It is not. You still own it. You still control it, right? Irrevocable trusts are credited. You used the castle analogy on our movie recording 2 weeks ago, but it is not creditor protected. Any lawyer telling you that, any TikToker, any sensationalized reel is flat out trying to grab a $500 consulting fee or something like that. A revocable trust does not have creditor protections. End of story.
Yep. And the tax benefits, it's still part of your taxable estate when it's revocable, because you still own those assets. That's one of the values there, is that you can own those. You control those assets just like you own your Schwab brokerage account. You can sell assets in and out of your Schwab brokerage account. You could transfer ownership to someone else. You can change the beneficiary. Same thing with your trust. And because you control that, it's still part of your estate, and therefore it doesn't receive any tax benefits of being in the trust. And that's something that people come to us fairly often with is like, hey, I watched this video on infinite banking where if the trust owns the policy and then I do this and I do this and then the trust pays this, it's like, then I can get all these deductions and stuff. And it's like, no, that's not incorporating a revocable trust into your life insurance plan does nothing that I've been able to find in pretty in-depth study of this, correct? Like there's apart from
Correct.
the trust can receive the death benefit when you pass, and that can have a much more fine-tuned control. That aside, if you look at the taxation of a trust, if the trust has income that it creates, you don't want that trust paying the income tax because it's even more of an aggressive tax schedule for income generated by trust assets. You want those assets taxed in your name because the income tax schedule for us is more favorable than the trust income tax schedule. So just don't think of it as this magic bullet. Think of it as just this fine-tuned layer of control that makes everything when you pass much more, much easier and much more efficient, right? Efficient.
Yeah. In English, because we got to keep that going at high level. In English, a trust lets you dictate exactly what you want to go where, to whom, and when. You can put in the trust a third of my money, even if it's 20 grand. Again, we're not talking about big numbers. If you're leaving 30 grand, 10,000 at age 35, 10,000 at age 55, 10,000 at age 65. You can pick all of that. It's control, 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 control. You're right. There's no magic bullet. There's no, fountain of youth here with creditor protections. The other things it helps you with is, believe it or not, maybe this is a con, but I'm sort of spinning it as a pro. It forces organization on you. Yeah. So we were talking about the wedding ring to your oldest daughter and other jewelry to your second daughter, correct? This is going to force you and your wife to actually sit down and say who gets what and write it down. And if it's a thing that has a title or a deed, if there's a clear paper trail of ownership, so a house, a car, etc., you actually need to go and retitle that to the trust. Frankenstein trusts are a real thing. That's the biggest challenge. What am I trying to say in English? You can go write a trust, but if you actually don't follow through, you've done nothing. You've done nothing. You actually have to go put in the work. And I'm doing my parents' trust and estate work now. We started it in October of last year and finished with the county, Broward County, Florida, where they live. And now we're moving on to the brokerage account, making sure it's titled to the trust and working with that custodian to do that. So it's a lot of work, but you're saving yourself a ton of headaches and tens of thousands of dollars in the back end of legal fees by doing it now.
And let's do a quick example of that, and I'll call myself out here. For instance, I had a truck and a camper, right, for a couple years, and I put in my specific bequests in my trust when I went through the software, and I said this truck and camper, like leave this to my wife, and if in the event that I pass, my oldest daughter, right, and I put that in there. I put those words in there, but the truck is titled to me in my name, and the camper was titled to me, and so I could say that in the trust. But that's not a trust asset. I said it, but it's still going to go through probate.
Yeah, you got to go to the DMV. You got to go to the DMV and change it to the name of your trust, not your personal name. That's exactly right. There's a headache associated with doing this, but that truck and that camper, if you don't do it, is going to sit idle for 12 to 18 months, depending on the state you're in. Probate ranges from 6 to 18 months. Some states are really good. Some states are abysmal at it. Are going to sit there idle for 18 months until a court decides who gets it. And if you wanted to leave it to your family, but the court says, no, there's still this teeny little loan on it, even if it's $200 left, you're on your last payment, the dealership gets it all. Yeah. Unless you handle it accordingly. So really, really interesting. So yeah, those are the cons. We ended up talking about the cons. The first con is that it is a administrative headache to make sure everything's titled properly, but it's worth it because otherwise you're going to make someone else do that and they're just going to resent you. The second con we mentioned, it does not have asset protection. You swallow that on TikTok, regurgitate it, you're done. It doesn't work. It does not offer asset protection. And the third is the funding. You have to actually fund it, right? I mean, moving these assets, but then you need to be thinking administratively. I bought a new asset. Does it need to be retitled to my trust or not? Yes or no? And so we're about to buy a new, and maybe the last car for my father. It's sad, he's 78, but it may be the last vehicle he owns. We're actually going to title that into his revocable trust, so it doesn't sit there as the one probatable issue that we have. So yeah, we're going through that process now. Yeah.
And so if someone were to sue your father, that truck or that car is still technically accessible, right? Because that's part
Yeah,
of his estate. It might be it might be harder for them to find that there is the trust. Is that a thing, or is it like they're gonna find it for sure? Like
they're
I'm
gonna
sure
find it.
good lawyers
Yeah,
can find it. Yeah. Now, what
yeah.
about well, like so we have this barrier with the truck that I didn't title to the trust. I just put it in there as a like I want to give this to my daughter, which is that's meaningless. Like it. Well, I guess it's not meaningless if it survives probate. If it makes it back to me after probate, then it will be delineated per the will of the trust.
Yeah.
But it wasn't there, and so it has to go through probate. But something like a wedding ring that can't be titled, that's fine. Like once I include that in specific bequest in the trust, I'm good to go, right? There's no
You're good to
probate
go.
issue there.
Yep. Yeah.
Okay. Now,
Yeah.
and then real quick before we move on, can we talk about the pour over will and how that bridges these gaps effectively? Having this pour over will as a complement to your trust, right? Effectively kind of catches everything, or is it like is that a silver bullet where I said in the going back to my truck example, my trust says it's going to go to my daughter, but I never titled it, so it actually goes through the probate court. But if I have this pour over will, which in my understanding says everything not listed in the trust I want to go to the trust, right?
That's a great
Is it
way to
like
explain it. That's generally true. Just remember that if there is that incidence of ownership, a title or something else, that can be contested then, right? Because then it's like,
right?
well, someone else may have a claim to this. But yeah, generally a pour over will is fantastic for all the things you may have forgotten or acquired along the way and you didn't update it. So if you went and bought you into vintage watches and when you did your estate planning, you had 3 of them, but over the next 10 years you bought 2 more and didn't list those 2 specifically, a pour over will is absolutely going to catch those. That's exactly right. It does a really good job covering some of the administrative gaps. It doesn't and cannot, by definition, capture things where someone else can show that they have a claim to that incidence of ownership. It's obvious you own the watch, but if you die and there's still a loan against your car, like yeah, you got to figure that out, right? So poor wills are very good. Yes, that's exactly what their function is a catch-all directive. It's a catch-all directive for all the stuff that you may not have explicitly stated that's clearly yours, right? With possession is obvious that it's yours.
So we listed the cons, and a pour over will can fairly effectively mitigate a lot of those cons. Not fully reduce the that con. Like it doesn't
Yeah,
wipe out the con entirely, but it does a good job at mitigating it. Now, also medical directives is another element of this, a non-financial element that's
that's the third
worth
one. That's a
mentioning. Oh,
natural.
there we go.
That's the third of the big 4, right? Is a medical directive. That's very different than a financial power of attorney. This is going to be a medical directive, medical power of attorney. I think everyone watched either ER or that new spinoff that's being sued by ER, but that's what it is. 2 doctors have to indicate that you are in an incapacitated state, in which case that document will decide what happens to you or who decides what happens to you. And so that's what it is. This removes the burden of guilt of having to make that decision.
Yeah.
Let's say you are incapacitated. You got to pick someone who you trust to make that decision. This is so morbid and sad, but yeah, who's going to pull the plug? Like how is that going to work? So that's important. And again, I just did my parents, and there were actually 27 iterations of that. And my mother put me in charge of her medical directives, right? So it's not incapacitated, but lost these certain functions. You know, it's the permutations of this are interesting, and we are going through that very emotional process of pre-deciding that stuff now, so that it is, for lack of a better word, robotic in nature
Yeah.
when that time comes to make that decisions. And this medical directive also ensures that your personal values, your religious values are honored. Some people believe in donating organs, some don't. It depends on the state. All of that is tied into this as well. So it's a very powerful document to remove a lot of the emotional trauma associated with this stage of life.
I found the trust program that Brian and I both use and that we've referred quite a few of our clients to, it has a section for this where you fill it in, and you're right, it's not comfortable going through that. It is morbid to think about and to think about in detail these specific scenarios, but you need to do it because you don't like if you're leaving. Yeah, it's a hard conversation to have with your wife when you're both alive and sitting there and saying, okay, well, if we both pass, how do we want this distributed amongst our kids? Like, and you have to have like, okay, we actually had that conversation of, okay, well, the wedding ring can go to one, the engagement to the other, or all other jewelry to one, and the wedding. It's like it's weird to have that conversation, but you owe it to the kids so that they don't have to make these hard decisions. And it's like the girls can blame us if they don't think it's a fair distribution, rather than forcing it on them to figure it out, and then they're creating animosity there. Now that's like a kind of an immaterial. I mean, it's material technically, but it's immaterial as far as actual long term what actually matters. What actually matters in a lot of all right, if I'm on a ventilator, like, do I want to live? Those kind of things. Don't leave that decision for your children to make. Like, have that conversation while you're comfortable sitting in a room together, alive, and life is good. And let's hope this doesn't happen. Don't wait until there's the pressure to make that decision. And if I think about, this is kind of a side tangent thing, but I often think about if I were in charge, there's a lot of things that I would do, like getting rid of Social Security. Nobody contributes it to the future. We're going to draw a line. There are people at a certain age that are dependent on it. If you're 55 plus, you very likely either are depend. I know people that are actively like that as their sole income right now. To take it away would be cruel because they will not they will die. Or they'll be destitute, right?
Right.
There is a line where I would figure out, like, you have to draw a line somewhere where you say that people that have planned on this and are depending on it, we're not just going to pull the rug out, but we have to draw a line somewhere where we say, hey, yeah, it sucks for you. You've paid into this Ponzi scheme for 30 years. And yeah, unfortunately, you're not going to get the benefit. And no one wants to fall on that sword. But our role as fathers in particular is to fall on every single sword on behalf of our children. So I would rather they say, hey, you've worked 15 years paying into this system. You're not going to get it. Hey, cool. I'd rather me deal with that than my daughters deal with that.
Yeah.
Of course I would. And so that's something easy. Like, I'm not planning on getting Social Security, and I would be glad to say, yes, my generation will not get it, even though we paid into it, even though we were stolen from and it's applied to this Ponzi scheme. At a certain point, and the 54-year-old who misses the cutoff, that's the worst. But you know what? That is your duty. Like, that's your duty towards the next generation. And so even more important, though, is these conversations. Don't leave these conversations to a grieving family that have to make these decisions on your behalf. And now you have all these elements of, okay, well, if he passes, then we get this. Like, I'm just thinking of this scenario where, one of us passes, and for our trust, everything goes to the surviving spouse. So say it's my wife. And now we have this large estate. We have a lot of death benefit coming. And my daughters are in a situation where it's like, mom's not, like, I don't even want to think about this, but like, that's the thing. You got to think about it. Like,
You got it. You got it.
Do they pull the plug because she's suffering? But then do they feel guilty because do they feel like, hey, is part of me wanting to do this because we're about to get $15 million? Like, I don't want that to play into it. And so, like, let's remove all of these considerations from them so that they don't have to. It's like, hey, mom and dad talked when they were alive and coherent and happy, and this was just a long ways down the road thought, and they decided this is what's best. And now our conscience feels clean. If we're going to pull the plug because they don't want to be on life support, however that conversation looks for you, have the conversation now and fall on that uncomfortable sword so your children aren't left in that situation. It's our duties as fathers to fall on these swords, in my opinion.
Yeah, no, I agree. The Social Security diatribe aside, that's exactly right. You got to do this planning for the family. It actually builds culture, it builds governance, it brings the family closer instead of divides them. And that's what we're really talking about. Everyone, family is everything, education is everything to me. And so, yeah, those are the pros, though. The go no go decision, religious and personal values could be done, and it removes the burden of guilt and decision from everyone else. There's three very specific cons I want to talk about to a medical directive. The first is vague language kills these things. Having been through this with another family member in the past, phrases like extraordinary measures or atypical circumstances make their way into these. No one knows how to interpret that. So make sure this stuff is clear, crisp, and concise, right? When you're reading it, if it doesn't make sense to you, it's not going to make sense to the doctor or the ethicist that may intervene at a hospital sometimes. So that's the first. The second is, if you move states, update this. Each state has very different rules as to how a directive is interpreted. Florida has very different, just given the demographics of that state. Florida finds other states flaky is a rule, is a word that people use in describing Florida physicians' interpretation of this. Because everybody there, as you get older, you're in different states of efficacy as a human. So if you move states, update it. That's critically important. And finally, hey, if you don't have that paperwork with you, it doesn't exist. Doctors have actually another legal framework to say if I don't see it, the paper, it's not properly signed and or notarized, it doesn't exist. This is to prevent one family, or to your point, Hans, of one daughter's like, pull the plug, I'm getting 7.5 million, right? Half of my of that death benefit. This is exactly designed to prevent that. And so you are required to have it with you on your person when going through this process.
That's a good foot stomper when you move for a lot of our audience. Now, I would imagine, I don't know this for sure, and I don't know if you know this, but when in the military we keep our home of record. So I was a Texas resident, even though I never lived in Texas apart from a brief stint in flight school. I was a Texas resident the whole time. Here on Coronado, you see every state in the union plates driving by because you keep your home in, but you see mostly Texas and Florida plates because every pilot, and this is an air station, changes their residency to Texas or Florida to get the income tax treatment. So I would imagine if you're a Florida resident because you go to Pensacola and you move around for 30 years with the Navy, you're still subject to Florida rules because you're a resident there. I would imagine, even if this all happens in California. Do you know?
No, so my understanding is the exact opposite. That's what we're trying to
Oh,
avoid. That a
okay.
Florida physician has a very different burden, that has a different interpretation of that burden than, say, another state, just given the demographics that they're in, and a military doctor may view it differently. So yeah, when to the extent possible, you can add and remove amendments really quickly by state, to do that.
So don't assume that you're stationed in California, but I'm a Florida resident, so Florida rules will apply if I die here or
Yeah,
if I'm incapacitated here. So
yeah.
that's a good like, and that's probably a good timeline every 3 years in the military. Every time you move, part of your checklist should be do a trust day, which turns into a trust month, which turns into a trust year. But
Just yeah.
update this like periodically. We should all be doing that.
There's a joke in there. Otherwise, it turns into a trust fall or whatever those exercises are called, where you
Yeah.
where you jump back. All right, let's get to the last doc, and then we can do some really cool. Because the final discussion is where does life insurance play in all this? Because that's where I think it's going to sing. But we wanted to give people a baseline. I wanted to take a quick step back and talk about the jewelry example you gave for your kids. Let's tie some ideas together, just as a quick refresher, like a mid-course check-in. Because you have kids, what do you need, Hans? What do you have to have because you have kids?
I need a will.
Done. End of story. That's all I want people to hear. Cool. Now, if you want specific things to happen to specific assets, what do you need?
A trust
Great. If you want to make those decisions, that goes where? The trust.
in your trust. Yeah.
Yeah. If you say, this is my stuff, I don't have time or the brain space, and you want to let someone else decide, you leave it in your will or you leave it vague, and probate decides. That's everything we've covered. That's really it in a nutshell in
And
English.
if you want a decent amount to be siphoned off to the legal system, to lawyers, to the government, leave it in probate.
And then the last document's a power of attorney, particularly a financial power of attorney. And so that's who's going to make decisions. If your spouse passes or you become, maybe you're not living in a hospital, but you have a decreased mental capacity, post-stroke, early onset Alzheimer's, some of these things where you are going to pick somebody to make those decisions for you. This is really important. The biggest pro for this document, even though it's an emotional document, both these last were very emotional documents, this prevents conservatorship. This is so critical. Conservatorship is the judge starts to make those financial decisions on behalf of you and your family. That is what we absolutely don't want. So that's the main reason to do it. The second reason to do it is this allows the household to run. Right? We care about making sure our family, we're not a burden to them. My biggest fear in life isn't dying. It's becoming a burden to the people I love. If someone has financial power of attorney, they can go pay my bills. They can go to their credit card company, send in an attachment and say, I have power of attorney, I'm paying this. They can use that document to keep doing the things of life that you may not be able to do anymore. Maybe you're so emotionally distraught after the loss of your spouse. I mean, there's so many ways in which this document helps. And what's cool about this document, this is the third and last pro of it, it can be created on a springing basis. You can have language that says if any of these events happen, this power of attorney becomes relevant. And so I have two brothers, right? I'm in the middle of two. I currently have I have the springing power of attorney, financial power of attorney over my parents, right? And this is to prevent me and my brother fighting over which bills and who and when and how, right? This will sort of like if my parents are both still alive but are unable to because they're just so old or technologies move so fast they can't log in, whatever. This prevents infighting amongst family as well.
So there's the springing where if this happens, then now this goes into effect. So your brothers can't manage your finances right now unless you become
Yeah.
like that kicks in at that point. There's also a durable power of attorney, which says you have this now, you have this power now, and in the event of incapacitation, because a lot of power of attorneys would terminate if you're incapacitated, right? If you don't have specifically a springing or a durable clause in there. Is
Yeah.
that
Yes.
accurate? Okay.
Yeah. Generally, right. All right. So let's do the cons. The biggest con is look, there's a lot of abuse here, and elder law, elder care is a hot topic. And one of my closest friends from high school is an elder care attorney specialist in Florida, and he talks a lot about this. Is people you see a lot of, and it's sad. You see a lot of children or third parties who have power of attorney abuse some of those privileges. So
Yeah.
there is the potential for abuse. That's the first con of this. So really someone you trust and some good mechanisms to make sure it's not being abused. The second, and this is among the more challenging, is banks are always highly skeptical of these, especially as they're older. Banks do have certain protections in from both a legal and a financial perspective to say we are over the short term not honoring this, this because it's 7 years old or 12 years old or 20 years old. So banks can often demand their own specific forms, is what I'm trying to say. So what you should do is take your financial power of attorney to the bank and say, does this suffice? If not, please give me your forms. And you make sure the bank's forms are in concert with your family's wishes. But I would say the majority of banks require their own forms here, believe it or not. So if you can take care of that while you're still alive, or before that springing power takes effect, you have removed buckets and buckets and buckets of red tape.
Now, in that situation where you hit that roadblock, is it like you said in the short term we're not going to honor this? Do the banks just are they like we need to do more work? Like in that event where you have this 10-year-old financial power of attorney, and they're like, hey, this is kind of a red flag for us. Let's review this. Do they eventually say, okay, we can't just hold on to your capital forever, even though like, do they give up at a certain point, or is it like you're not touching this, and then that could put the person, if their intention is that person is their, they would still make that decision. Are they just blocked from it permanently, or how do they
Not
do it?
permanently, and then the courts get involved, right? You typically
Okay,
get a lawyer, but
go
the best way
slow.
to do is have it be relatively clear, but just make sure they have their own forms. I would say most banks have their own forms for power of attorney. They're not disputing whether or not you have it. They're just saying there's a discrepancy in this form and our form. So just as soon as if you're going through this planning process, again, it doesn't matter if you have 10K or you have 10 million. You need this stuff. Otherwise, it takes some people 2-3 years to settle somebody's estate without this stuff in place. You don't want to be a 3-year burden after you die on your family, right? All I'm saying is once you have power of attorney, take it to the bank or banks that your family banks at and says, this is what we got. I want to put it on a file. Do you have another supplementary form to this? We're going to sign it now, and that's it, and you're done. It's just making sure you know that, so it doesn't go out of sync, so to speak.
That makes me feel like I feel validated in keeping my capital stored, like my pooled capital stored in a life insurance contract, because this is not applicable there. Now, you wouldn't have, I mean, you would want to have, you'd have different considerations in having that person access your life insurance policies, but at least we're not dealing with the bank being a blocking mechanism here in that event. But I don't really keep too much capital in the bank. So you're also talking about like Charles Schwab and places where you invest and have brokerages. Is that also applicable here? Or are you talking mainly your Chase Bank, USA, like where you just save money?
Both, but 99 out of 100 brokerages operate much more efficiently in that
Yeah.
the minute you have these docs, you send them in and you say, this count that was joint row and row spouse is now owned by row and row spouse revocable trust. And they'll say, great, we need to see the doc. We need to see that it's notarized. We need both sets of signatures. And then they get it. Their legal team reviews it. And usually within 3 or 4 days, when you log into your Schwab account, it is retitled to your revocable trust. So that is much, much easier to do than actually, believe it or not, accessing your checking account.
Now, can those power of attorneys and the medical directives, those can live in your trust, right? Like those can be incorporated into the trust document,
Yeah,
correct?
you,
So in
generally,
that
yeah.
case, you can solve a lot of this, like logistically, by having your trust as a beneficiary of your brokerage account. Is
Sure.
that like,
You can be, but they're often different documents. It's part of your estate plan, but they're often different documents because you don't want to be handing your trust documents, which you're trying to create privacy. Remember, that was the biggest reason we did trust. We're trying to create, I don't want to have to send my whole trust document to a medical team. And now all of a sudden they're like, oh, this family has $12 million. We have this new robotics procedure that has a
yeah,
0.06% rate that may solve, we could charge them and it's not covered by insurance. I'm not saying anyone would do that. I just mean you want them to be separate because each one has its own goals, right? Each one has its own use case. Again, the will is the catch-all and the kids. The trust is privacy and skipping probate. The medical is removing the burden, having my wishes done, and the power of attorney is actually getting things done, moving money. They're very different in their uses, and that's why they're generally considered separate documents, right? So
yeah,
and if you put it all in the same trust, you're going to pay the same amount. Trust and estate planning can be pretty cheap, you know. It doesn't need to be the most expensive thing in the world. Um, and then obviously as your wealth and complexity scales, the cost of it scales. But I think we covered the big four. Do you think anyone in the audience we missed something for them? Or
no, I think that's a fantastic overview, and I'll just wrap up the thought I just said again because people think I think people that are thinking estate planning, which is good if you are, you should be. Most you don't just fall into it. You don't just fall into it by working with a CFP to just get like some investments in place. It's very important to think through, and I think a lot of people come to the understanding of I need to do this from learning about trusts, and trust for non-wealthy people have always just seemed like something out of reach. And I think now with the internet, with the fact that you can kind of like a one-time fee and get this document set up, like the barrier to entry to getting a trust is a lot lower, and that's what people think of when they think of estate planning. Cool, I've got a revocable trust in place, I'm good to go. Well, this textbook, one chapter is on trusts, right? Of 14 chapters, one is on trust, chapter 8. It's important, but it's not the whole thing. And so don't, just like you don't want to just, don't just file with TurboTax and think you're good, and don't just set up a revocable trust and then think you're good. There's a lot to it, and you should work, like you should outsource, at least get a check on everything that you're doing and make sure you're not missing anything, because you don't know what you don't know, and most of us don't know a lot, especially in estate planning.
yeah, and again, like I said at the very beginning, everyone's estate plan is as unique as their fingerprint. But stuff that has a beneficiary, like life insurance or an IRA, typically doesn't need to be named because the beneficiary will supersede most documents anyway. So it's really just about kids, no kids. What do you want to have happen, and how can you keep it simple? Estate planning gets tough because people use these stupid specialized words to make themselves sound smart. That's why I've been trying to keep us high level. Kids, no kids, stuff, no stuff, title, no title. Okay, great. That's how you make those high level decisions, and then you move on. I mean, it's for me, the motivation to do this has always been my biggest fear is actually being a burden to people I love. Okay, I think the last dialogue, and it could be long, could be short, and where I think I have hopefully something to add is what role does life insurance play in all this? And then the whole second half of estate planning is the whole revocable versus irrevocable, and some of these definitions and terms. So is it this episode, Hans, or we just continue rocking and
No, let's
rolling?
let's just keep doing it. Yeah, I think this. I'm personally very invested in this conversation. Like I said, it's trust year now, and I'm also becoming a co-trustee of a 9-figure estate, and so that's part of my motivation for really like estate planning, not just in my CLU. And it's not. I'm not just trying to pass the test on estate planning. Like I'm trying to go as in depth as I can, because that's becoming an imperative. So
All right, so let's do this, and I'm going to end up standing up when I do this. So I apologize if someone's actually watching us, and I'm bopping around. I get really excited about this. We're going to have to use some jargon, and then I'm going to try to find English words so we don't use it anymore. I am not an attorney. Everyone needs to know that. You're not either. This is not legal advice. So I want to keep it very high level because there's a certain 2 or 3 key decisions you have to think about, and then you have the attorneys handle the rest. So I want to just focus, Hans, on what are the big distinctions and decisions to make. And the whole time from here on out, let's talk about how life insurance is probably the magic bullet in estate planning, if not tied for first with one other technique that I'm going to go over.
Yep. Yep.
All right, let's rock and roll. You can see as I'm fidgeting around and pushing my chair out of the way. The first distinction in the estate planning world, first thing to learn is estate tax and income tax are two different concepts. And I think a lot of people think they're the same, and they're not, right? The estate tax is the government taking 40 to 50% of all of your net worth above 30 million if you're filing married. That's the estate tax.
Yep.
Okay. Income tax is what we all know and dread on April 15th, and for the rest of us on extension who don't have a cash balance plan, right? Dread, right? I'm trying to make you laugh, Hans. I usually make the co-host laugh, and you're a tough nut to crack. Okay, so income tax and estate tax are not the same. So that's the first thing to kind of throw out there that I'll weave back and forth between. The next biggest distinction or decision in estate planning is the difference between revocable and irrevocable. Okay, those are two words that I don't want people to Google. Revocable, from here on out, I'm going to say I own it and I can access it, and irrevocable is someone else owns it.
Yep.
Okay, yep. So the whole world of estate planning is I own it or some other entity owns it. That's where we're going with this. Cool? Okay, so now let's tie it back to statement one. Premise one was the difference between income and estate taxes. If someone else owns it, it is no longer subject to my estate tax. So irrevocable means I don't own it. If someone else owns it, another entity owns it, it is no longer counted against my $30 million exemption. We're like 90% done. Then there's all these ways to twist this and do really cool stuff, and that's what I want to get into. But those are the major distinctions. So if it's revocable, meaning I own it, and there's more than 30 million of it, half of all that money above 30 million is owed to Uncle Sam.
Let's just put some numbers on this real quick. Let's say, and specifically with life insurance, you have $30 million worth of real estate, precisely. If that's all you have, that amount is shielded from the estate tax. You would get a credit for the 40% of that applied to the tax that you would pay, but effectively over $30 million, you're not paying estate tax on that. Let's say you have a $10 million life insurance policy on top of your $30 million of real estate. Exactly 30 in real estate, $10 million death benefit in life insurance. Now that death benefit's tax-free, but if you own that policy, i.e. you're doing infinite banking with it, you're taking policy loans, you're using it for the reasons that we likely set it up for, if that's the policy you got through us. If you own that policy, even though your beneficiaries will get $10 million tax-free and they'll inherit $30 million worth of real estate, the overage on top of that 30, so in this case $10 million worth, is going to be taxed at say 40%. And so your beneficiaries would get a tax bill, not for the death benefit itself, but the estate tax bill would be a $4 million bill that they're going to get. And so that's where you have a lot of situations where people don't intend to have people think, as an example, there's someone here where the father died and left assets to the daughter that he didn't like, left her a giant estate tax problem, and she had to liquidate a lot of assets. And that's
maybe he left her that because he didn't like her in your story.
That's exactly it. No, that's why. And there's more to that. I know the background on the story because of how the house was purchased, but that she had to fire sell the house because she had this enormous tax bill due, and we don't really think about that. I would say my network, my people don't think about that. We don't think about how much over $30 million is going to get taxed by the government. But I want us all to have that problem of how it's a challenge to solve, and it's a solvable challenge. But it's a good challenge to have if we're leaving that much, I think. But yeah, so just for basic example there, over 30 million, it's not like if you have $31 million, 40% of that is going to be taxed. It's the overage of the 30, that 1 million in that example, or with the life insurance, that 10 million over the top, that amount is what would be taxed at 40%. Typically, I mean, it's scaled. So there's an estate tax scale, just like there's an income tax scale, but it maxes out pretty quickly at 40%.
Yeah, right? So we should say 50. You can go to 50, including state tax and other inheritance taxation. So let's just say half of your wealth above 30 million is subject to estate taxes. Okay, so if it's in my name, revocable, you do have some benefits though. Let's go back over our list from link it to the estate planning, not estate tax planning, right? Because we've moved from estate planning, have your big four, to estate tax planning. If it's in my name, I can change it. I can move stuff around, right? Yeah, I'm giving it away forever. If I still own it, it's in my name. Um, you don't get asset protection. Same as what we talked about before. And a lot of people think that, but no, you don't. You don't get asset protection. The assets, if it's in my name, are still subject to those taxes, like you just said, and you're the owner of it, right? So why is that relevant to go over? Because the more interesting stuff happens when you move it out of your name. You have it owned by another entity, an irrevocable trust, but it's out of my name. You are signing it away. It's really hard to get those assets back. Now, there's ways to do it, which I'm going to cover because that's the most important thing we can cover today. But it takes a long time to build there. The second thing is you now get creditor protection. So
Yep.
when you move it away from you, the government says, "Oh, it's not yours. It's this own legal entity." That legal entity is a fortress. You used last time we spoke the castle analogy. It is a castle with a moat and a dragon and a wall and all that stuff around it, right? So
Yep.
it gets creditor protections, and then there's ways to further enhance that with asset protection trusts, etc. And then when you move it out of your name, all that money above 30 million is not subject to estate taxes. That's the
Yep.
biggie. That's the biggie.
Yep.
So there you go. Those are the major distinctions. So now let's start pivoting and moving this board. What do wealthy people do?
Let me just
And how?
just
Yeah.
throw one. My one situation in dealing with this, my first exposure to this was a client with about we'll say $60 million net worth, but higher than the estate tax. Got a policy, wanted to do infinite banking, understood it, has a big real estate business, wants to start taking over the banking function, everything we talked about. Pays a large premium, about $250,000, have this great setup going, and $6 million death benefit. And then it comes to the estate planning. Their estate planner freaks out. Freaks out because the policy is in his wife's name, owned by his wife, and the policy's on his wife. And so he said, hey, this policy just added 40% of that 6 million there is now 2.4 million, about 2.5 million. And we're in California, so we'll call it 3 million, is now going to be taxed. So we freaked out. And so you need to move this instantly to an irrevocable trust. And so I'm have a lot of sleepless nights trying to learn about this, because in my world, that's not a thing. Like, at this point, I didn't think through that. I didn't understand it. I'm not an estate planner. And so I didn't think about the fact that with their net worth already being over 30, every dollar of life insurance death benefit in her name or in his name is going to be subject to that estate tax. And so we moved it to an irrevocable, and now there's a 3-year timeline. She has to outlive 3 years. Otherwise, it goes back into her estate, but we're almost there in July. We're going to pass that 3-year mark. So now when she passes, after that point, it's not in her name. However, and so you might be thinking, well, why wouldn't I put my policies into an irrevocable trust? If I get credit protection, if like all of these benefits of it being irrevocable. And I think when people watch trust TikToks, they're thinking about the benefits of an irrevocable and applying it to a revocable is mostly what I see. There are benefits, right? Because now if they get sued, if a tenant sues them or something, that $6 million is secure. That $6 million is not subject to estate tax. So the children are going to get that full $6 million without estate tax. That's great. But what can he not do with it? He doesn't own the policy anymore, or she doesn't. So the intention of the policy was to bolster their real estate business. Now we have our own working pool of capital. We're not relying on the banks. Well, now in order to like that, now the premiums have to be paid by the trust. The trust is the beneficiary, and only the trustee can take out a policy loan, and it can't go to him and their business. Otherwise, it's going to be on shaky ground with the IRS for preserving the irrevocable status.
Yeah,
So
they're going
we
to claw it back. Yeah.
effectively removed control intentionally, and therefore we can't really do IBC with it. So there's a big pro here and a big con, at least from the perspective of the intention of the policy, right? And you would argue that might not have been the right move, and I'm really curious on that if we want to get to that later. But
at that level, let's just go there. At that level, insurance should almost always be owned irrevocably. I agree with the attorney if their sole goal was tax minimization. But here's what's so interesting about that. I was going to go down grantor retained and how to make a trust defective on purpose, and maybe we'll get there. But let's just swim in life insurance proper planning, because we all love life insurance, right? It's the remnant way, right? And so if you move, so what does this mean? In my name, out of my name is the distinction. I don't want to use the terms revocable and irrevocable. Okay, I'm allowed to move 30 million out of my name. When I start moving more than 30 million out of my name, I start to hit that tax, actually, right? So I'm only allowed to move 30 million out of my name. So what technique do I use with my clients? And even if they have IBC policies, more often than not, I tell them to keep the IBC policy in their name, even if it's a taxable event. Okay. What I then do though, Hans, is depending on where they are on their human life value, I buy convertible term in the out of my name trust. If you buy $10 million, $20 million of convertible term, let's use 20. If you buy $20 million of convertible term, how much of your estate exemption does that use? You're allowed to move
Out of
30 out. You move $20 million of convertible term. You buy it in the irrevocable trust, the out of your name trust, out of your estate trust. It consumes $0 of your
yeah,
exemption. Convertible term is counted as $0 of moving. So you should be loading your
it has no
irrevocable.
present value.
Yeah, it has no cash value. It's got no equity. It's convertible term. It's a liability, right?
Oh man, yeah,
This
yeah.
happened last time where you like had these moments, and I feel like I got to slow
That's
down.
and I was like,
That's
all right,
good.
well, I know we can move 30 out of our name, so we just move 2/3 out of our name, but no,
No,
the
zero
asset
dollars.
value,
It's
asset value
zero.
is $0.
That's what zero.
This
So
term, I mean, it's
I just finished a case. Really proud of this case. 42 million of convertible term moved, purchased irrevocably out of their estate, right? And we've used none of the other $30 million exemptions still. So, and his is a illiquid mega business owner here in town. And we're going to do some other cool estate planning. We can walk through this case as well. Obviously, everyone is and will remain anonymous forever, right? But you should be accumulating convertible term outside of your estate. Why? One, it doesn't count against your estate tax exemption, but the second reason is just as important. And I want to bang the desk and I want to scream because I'm passionate about this. Being insurable is a form of currency. Last time I rocked your world when I talked about taxes and asset class and annuities, feed policies in retirement. This is my view, my unique view, and not unique. I've learned it from other folks as well in the space, but being insurable has value. Because if it doesn't count as against his estate exemption, and this guy knows he's going to have an estate tax problem, you should buy convertible term and park it out of the estate. Okay,
yeah,
what does that do? Keep this chain of this logical chain going. This is really interesting. We can use my case or we can use your case. Which would you want to go? I can kind of, I think I'm facile enough to do this. Facile enough. I can't say facile. One of my clients gets mad at me. I'm facile enough to do this. Do you want to use your case?
yeah,
Okay, so your guy has a whole bunch of real estate, is what you had said, correct?
yeah, yeah.
Primarily real estate. Real estate's illiquid. Okay. If he and his wife pass, the real estate, you have 6 months and 1 day to pay the estate tax, right? If there's not enough liquidity, right? If there's not enough liquidity, you have to be a forced seller to your example, right? Well, if you have this convertible term, good planning is you convert it and start to pay those premiums. I still want whole life in the irrevocable structure. I'm saying buying it there doesn't count against your exemption. You've been feeding this policy out of your estate. When the IRS comes and says, let's say this real estate is worth 60 million, okay? And it's in their name, and I actually recommend they keep the real estate in their name. Most people don't do this. This is unique. I want you to keep as many assets in your estate as possible, believe it or not, but have so much life insurance out of your name that when Uncle Sam, in this case, says your net worth is 60, you owe me 50% of 30, right? 60 minus the 30 exemption, right? That you're allowed. You owe me a 50% tax on that remaining 30. You owe me 15 million. You say, cool. Your estate says, cool. Yep, we owe you 15 million. Take it from the life insurance policy that just paid out. Take it from the
Yeah.
death benefit. It's got to be whole life. You got to convert it and do it. You got to pay up for this, but you basically didn't use any of your exemption to get guaranteed leverage of the death benefit. The money will pass upon death to the estate, and then the estate says, okay, don't take it from my real estate. Take it from this pool of liquidity that just was created upon death. Now, two spectacular things just happened. One, is the death benefit taxable?
No, not
No.
any
So
of
even though it's owned out of your name, it's still not a taxable event because it's life insurance. All that liquidity and wealth was just created tax free. Second, and here's the magic, here's the silver bullet, lock in, listen up, pull over, park your car, right? If it's in your name, whether it's real estate, a privately held business, the S&P 500, if it's in your name, you get a step up in basis. So now, let me back up. Step up in basis, for people who aren't familiar with this, is the government says, if this asset transfers to you, transfers to somebody else, but it was in your name, we will pretend as if they bought it that day, the day you died. We will. So if you bought the S&P when it's at 700 and it's currently trading at 7,700 or 8,000, let's say, and you die the day the S&P hits 8,000, the U.S. government says you get to own the S&P 500 as if you bought it at $8,000 at the index level. So I'm not using my exemption by buying it a convertible term initially, starting with convertible term. You do got to convert it and pay for it. I'm creating liquidity, and I'm getting a step up in basis.
That's incredible. And that's not every asset. Like if you pass an IRA, they don't, if you put $100,000 into your IRA and it's grown to $1 million, when you die, if your beneficiaries sell it, they don't get $1 million as their basis, right? Because that's income in respect to the decedent.
Yeah,
category,
that's exactly right. Yeah.
So like
That's different. That's in the qualified system. Yeah, that's in the pre-tax system. All of this is after tax money.
Out, like, and that's part of knowing what's going to pass and how. And there are assets where your basis is going to carry over from what the decedent had, and IRAs, 401ks, right. That's one of those categories where you keep their basis. So it's not just like a blanket, whatever their net worth has grown to, you get it. But with real estate, that is the case.
It's exactly right. And with stocks, anything in your estate, anything gets a step up in basis, right? Especially if it's easy to mark. It's hard for your antique map collection to get a step up, but it will. And you can go through that process, and specialty firms to do it because you should. You don't want to leave more to the government than you have to. I know your views on this. We're not going down that rabbit hole. We spent 12 minutes on that last episode. It's your patriotic duty not to pay too much in taxes. Heard. Okay, we're not even done with this analysis yet because the dominoes don't stop yet. Okay, we got to buy convertible term for a cost of 0, right? You do need to convert it to whole life because if you live longer than the term, now all that estate planning shield goes away.
You need to convert it to whole life, presuming you don't die during the term.
Yeah, presuming you don't die during the term. Okay, so in your case, there's 2 forks now. There's 1 fork, 2 paths rather. If you kept the life insurance in the estate and didn't move it out, yes, it would increase your estate taxes, but you get all that extra liquidity. So I never have a problem with people keeping policies in their estate as well. It is more efficient to move it out. I want to be clear, but if they're doing IBC and they keep an estate and they haven't used their human life value, you should be aggressively buying convertible term out of their estate for them. What would I do in your case? That's moved irrevocably. I wouldn't touch it. Leave it out of the estate. Get some more convertible term for future planning. Insurability is currency. Please don't forget that. Mm-hmm. Does this family have kids? Hans?
Yep, 4 kids.
Then they should be buying the maximum amount. I would do IBC on the kids is how I would handle it. Okay, why? This is how you build multi-generational wealth. And I'm going to steal concepts from God. I always want to give credit because I'm a learner. I'm not like someone who has unique ideas on my own. I just read everything. Garrett Gunderson's done a ton of work here, like Rockefeller Method. It's related to IBC, to Nelson Nash's book. I would immediately start IBC on the 4 kids to the maximum legal amount, typically $1 million or 1.25. You can get some exceptions here and there. Leave those in your estate because they're on the kids. Build massive, the biggest legal amount of IBC, and use that for real estate on mom and dad, patriarch and matriarch. I'd move that out of the estate. So I can still pay a ton of premium and build their policies, their IBC on the kids.
Mom and dad. Did you say move? Did you say to move out of the estate?
I would get as much convertible term on mom and dad on patriarch and matriarch out of the estate. I actually would. So this attorney is on the right path, just didn't complete the analysis. Buy the absolute biggest amount you can get your hands on the kids, provided the client has the cash flow. We don't oversell insurance, right? But provided the client has the cash flow for this, right? Now you have 4 policies to do IBC on for as long as you want. You don't have to transfer to your kids ever. But what would I do? I'd be building these huge policies on the kids. The kids are guaranteed to get something because they have a taxable estate. Whether you've done planning or not, the kids are getting something. You've just created the liquidity for the kids to buy assets out of the estate. And if they don't need to because they all got a step in basis and it's all liquid, easy stuff, in your trust, in your documents, you say, okay, 4 kids, move this policy out of your estate and keep your assets in your estate. So we're working our cost basis up across every generation and creating a cascading waterfall of liquidity, tax-free liquidity for each generation thereafter. This family tomorrow, let's go get insurance on the kids.
Yeah.
That's how you do it. Now you're doing IBC, you're acquiring real estate, you're building tax-free wealth in your estate via life insurance. You've created secondary planning down the road, and we go buy a bunch of convertible term in the irrevocable trust. You've just built a 2 to 3 generation system that self-completes.
Yeah, that's incredible. The idea of creating a large body of tax-free money that will pay the tax bill that's inevitably going to come due, like that's it's brilliant. I mean, it's just so much more comprehensive than either grow as much money as you can without thinking about estate tax at all, or get everything out of your name to minimize estate tax, and that's the main goal. Like there's so much more nuance here, and that's really powerful.
Yeah, and I would still use the $30 million exemption. Everything that attorney said is right. I'd be moving stuff that is tax efficient out of my estate. I would be moving stuff that produces a cash flow out of my estate as well, because then that cash flow off those assets, even if you just go buy dividend growth stocks or you put one of the pieces of real estate in there and it's good cash flowing, a big piece of commercial real estate, right? That cash flow that it's creating will be used to fund that policy, that conversion from convertible to whole. If you don't have cash flow, that's where premium financing comes in, by the way. That's what that industry exists to do, right? Solve that problem for ultra high net worths. But that's exactly right. And so I would take S&Ps and move them out. And instead of letting the S&Ps sit there and have a cost basis problem, I would do direct indexing, right? I would do a mathematical parametric overlay, statistical overlay on the portfolio to work the cost basis up while producing cash flow, and have that cash flow other than what's needed for tax, because we'll talk about taxation of irrevocable trust in a minute, taxation of trust out of your estate, and have so much life insurance in there that it can cover the bill for the matriarch and patriarch and any bills in the estate. That's exactly how you do this. That's why this asset is so delicious and nutritious. And what's so fun about it is if you start IBC on the kids, keep those in your estate, and when they're older or in your directives, have each of those policies move to their irrevocable trust, right? They're out of their estate. They don't own trust, and you've just created the liquidity for your grandkids to make sure they get some money.
Yeah.
So that's what I do for my ultra wealthy clients, and I'd say we're among the most advanced at doing that, Mark and I, for that type of work. And we deploy these techniques for our clients, 50 million plus, 30 million plus, 40 million plus. We're working on two very large cases now where clients are like, they love it because 9 out of 10 advisors say get as much out of your estate as possible. And we say keep as much in your estate as possible because you want control, you want access, you want to step up in basis. Just make thoughtful provisions for your estate out of your estate to continue to grow and to create liquidity. Okay, we can go right now. This was still the elementary version of estate planning. Do we want to go to middle school and high school and Ivy League, or do we want to cut this episode off because we're already at an hour and 20 minutes?
We are going to do a conversation with your estate planning guy, correct? Where we talk about the like all kinds of the grats and
we could do some of that, but yeah, I'd rather him come or a specialist come on. And I know you can have a teeny attorney, but there's one advisor who I trust to do all of my estate planning work with me. He works at I think they created premium financing, SEA Capital. His name is Dan DeTusa. So he can come on and get much more detail, but I wanted to keep it high level. Exactly. This is how the strategy works for it. So for your client, say, hey man, keep as much in your estate as possible, except move up to 30 million out because it's free to do so. Right? Convertible term doesn't count against it, and make sure the stuff that's out of your estate is the stuff that's going to appreciate rapidly and or create a cash flow, because the cash flow can support the policy payments if you want, and the rapid appreciation avoids the 40 to 50% estate tax. Okay, now it's time for the complete mind meld here. And this has nothing to do with structures, slats. Cross slats are really cool. A slat is a spousal lifetime access trust. But within the world of estate planning, there's 2 more distinctions that we need to learn. So we learned I own it or someone else owns it, right? Revocable and irrevocable. The next important distinction that everyone should know if you're down this irrevocable path, again, below 30 million, stick to the big four documents. Okay. Above 30 million, in and out is the first distinction. The second is what's called grantor retained, a non-grantor retained. God, lawyers love big words. Grantor retained means I pay the taxes on it.
You maintain the income tax while removing ownership.
Yeah, I removed exactly right. Like I gave these 2 buildings to this legal entity, but the taxes on those buildings, I'm still going to pay them.
Yeah.
Non-grantor. Yeah, go ahead, please.
And why would you do that?
Because you are effectively having 100% of the growth of the estate be tax-free.
Right.
All of the,
yeah,
you take the hit now so you don't pass on a tax problem. And that's the first reason. The second reason is what you alluded to very elegantly earlier in the episode was taxation of trusts is nutty, a really highly technical term coming, nutty, bananas, bonkers, insanely punitive. The highest tax bracket for trust as of 2025 starts at 15,000 of income. You move to the 37% trust tax bracket at I think 15 or 15.5. So
it's like poverty, half of the poverty line, like the poverty level in America, like less than half of that, it hits you the highest tax bracket in a trust. It's like, it's ridiculous.
Right. So I don't actually know if any of my clients, and I've been doing this for a while and in the ultra high net worth space for a while, who have the trust pay the taxes. There's a couple of cases where it makes sense legally because the assets or et cetera, but really almost the overwhelming majority of out of your name trusts are structured where the person who gave the money, the grantor, the person who put it in there, will pay the income taxes along the way. Again, that's why life insurance is really important because there's no tax, right? You could have that's why there's an argument to be made about moving a fully seasoned IBC policy out if you wanted to, because all the growth in the dividends are going to stay tax-free, right? There's nothing wrong with that either. And so tax efficiency matters even more in this world. Okay, that was the first divide. Who pays the taxes? Without getting too technical, I do want to say what I think is the closest thing. There is no silver bullet in estate planning. There's maybe a lawyer who hears this and shoots me an email. I did my first ever podcast 3 weeks ago, Hans, 4 weeks ago, right? The Caleb one and then you 2 weeks ago. And man, do people chew you out on the internet for trying to teach and share. But like we said, we don't worry about the comments. There's a way. Let me back up. Once you move something out of your name, it's very hard to get access to it again. We talked about that, right? Okay, here's the closest thing to a silver bullet. Call it a silver medal, right? You're not quite the gold medal. It's not quite the gold medal. I think life insurance is close in estate planning. There's a way to make an estate that's out of your name. You pay the taxes and retain the ability to move assets back and forth.
Yep, intentionally
Defective grantor trust. You spoke that out perfectly, right? You want to make your irrevocable trust intentionally defective. Okay. Yep. What a crazy word for ultra high end planners to say this is intentionally defective. You move it out of your state and you keep paying the income tax. This is essentially a tax-free gift, like we talked about, paying the taxes to them. So why is it really important to do this? You can move assets of equal value in and out across. So you got privately held company currently worth $1 a share, then you move 100 shares out there, so you move $100 out of your name. You've consumed 100 of your 30 million of estate tax money. You expect this to rapidly rise, right? You get it all out of your state, it rises, right? It grows to 50 million. Okay. You can then move that 50 million back in your name. I'm not sure why you do this, but showing a hyper stylized example, right? And a 50 million of something else out. And it wouldn't trigger a tax issue because of that. You can hot swap assets back and forth between the two. So you can start to manage liquidity and basis. You really use this technique to manage the basis of the tax burden you don't want to leave out of your estate. Remember, the basis is solved in your estate because you get a step up. So you want, over time, you want to get as much appreciation out of your estate if it's grantor retained, meaning you're paying the income tax. But when you get closer to dying, you actually want other things to happen where you want the lowest basis stuff in your name and the highest basis stuff out of your name, plus the life insurance to create liquidity, because the lowest basis stuff gets a step up, the high basis stuff doesn't. And so, yeah, you make a trust intentionally defective. while retaining the right to pay the income tax, not the estate tax on it.
Now, why
That's
do they
everything I know. You've
allow?
reached the end of my brain here, Hans.
Why do they allow that? I mean, I understand. You know, you got to put on two different hats. You got to put when you're. I think when you're thinking through estate planning and the tax code, you got to put on the hat of, you know, Tom Wheelwright. This is a map. This is a roadmap to steer behavior towards desired intentions. We can't house everyone in America, so we incentivize you being a landlord, buying real estate. We can't take care of everyone's beneficiaries, so we make the death benefit tax free. Of course, death benefit predates like the tax code, so it's not, you know, like, but all of these, like, it's a way to steer behavior. That's the one side of it. There's also the cynical side of it, which I would say my audience more resonates with. What are they actually trying to do with this, right? And so all of these, especially like when you start reading through the intricacies of like the generation skipping transfer tax, how everything is calculated, and it's like, if this, then this, then this, then you owe us this much. But if this, then this, then that, then you owe us this much plus the. It's like, it's so complicated, and I think you need to be able to make the argument of, here's what the government, the government, the behavior they want to incentivize via this section of the tax code, and also here's why. Like, of course, a classic example: why qualified plans? Why do they give you that tax benefit of a, you know, of a qualified plan? Well, they're not just trying to get you tax free, you know,
Right.
appreciation in retirement. They get to sit on that for 3 decades and earn on it for 30 years while it's locked away from you. So like, there's a give and take there. Why would they allow? I understand why they have revocable trusts, and I understand the trade off. I think we made a pretty good, you know, the trade offs between irrevocable and revocable, and there's a place for both of them. But this intentionally defective grantor trust kind of bridges the gap, and it's almost like the best of both worlds. So, and that's not like you. It's not like Roe and Hans are saying this is defective. Like, that's the official, like, in the textbook, intentionally defective grantor trust, IDGT. Like, that's an actual category. So why is that allowed? Do you know, or can you speculate?
I know two of the three major rules as to why, actually. I've done a lot of research into this because it seems like an opportunity in the tax code to drive a Mack truck through, and it isn't, and it isn't, because the first reason why they allow it is from their perspective. You haven't changed the net economic value. 50 million in your estate in asset A versus 50 million out of your estate, and you swap them. The net economic value is the same.
Okay.
That's the argument to allow people to do it, is because eventually the IRS is getting paid, right? Because remember, out of your estate doesn't get a step up, and they're paying taxes on that. They're getting taxes from you today on that trust. So yeah, the net economic value is sort of stays the same. And then the second reason is this idea of they didn't offer the power of substitution to let you do whatever you want. They offer the power of substitution because what it does is it actually makes the burden of the fiduciary burden on the named executor, the trustee, more responsible. Meaning you'd have a harder time doing this with certain corporate trustees than others, right? Because there is some risk of doing this. So it's not something you do all the time or often. And what was happening is that people were putting these assets in there and still controlling it. The IRS has clamped down much more so on the control element than the hot swapping element. So
Okay.
that is particularly important. And then the last reason, I'm not as familiar, so I'm kind of familiar with two of the three. I remember reading a lot about Revenue Ruling 2008. 22 was this landmark ruling. I don't know enough about it to be a credible expert. I recommend you find somebody to bring it on and talk about it. I'm not well versed enough, but from the IRS's perspective, they're getting their pound of flesh either way, now or later. And in fact, they hope your rapidly appreciating stuff is out of your estate because you're not getting a step up on that. And eventually they get a bigger piece of a bigger pie, or the same size piece of a bigger pie, right? So it kind of makes sense in that they're willing to defer, like we talked about before. They want to tax you on the harvest, not the seeds. This is the same reason
Yeah.
why they give you the tax deduction today for an IRA, for a cash balance plan, is they know it's going to grow, and they would rather tax it on the higher amount than on today's amount. So the same logic applies.
Okay.
Same logic applies, right? If
In
you
the
were
same way that
to, yeah,
like the step up in cost basis, that's great for your beneficiaries, that they inherit this house with whatever it's valued at today, even though you paid much less for it. But the reason that they're allowed to do that is because you kept it in your estate and you paid the tax on it. Or
you're right.
maybe not necessarily pay the tax if you're under the 30, but it's like, it's one or the other. Like, someone's getting
Yeah,
taxed on it. not
Yeah,
get
and
around it.
if
So
you can more than 30 million in your state, which I generally recommend, you still want control, you still want access. Just make sure you have a safety net, a valve, a parachute to say, fine, I'd rather pay some estate tax for control and the step up than not. And some people this may not resonate with, right? The traditional approach is get as much out of your name as possible, die with 29.9 million, right? I'd rather die with 100 million, get the step up, and have the tax bill covered by life insurance. But if you're uninsurable, this goes back to, look, insurability is a currency. So if you're uninsurable, you can't use these techniques. If you weren't planning, or you're one of those people who immediately shuts off the dialogue when the word life insurance comes up, good luck. Yes, then your
yeah,
endeavor should be to die with 29.9 million. Yes, then that is your new goal, instead of saying, no, I want control. All right, I want access. I'll still hold it revocably so I get my privacy from our very first discussion. I want all those things. I want to step up. So enter life insurance and enroll at place. And yeah, without that technique, I would be on the other camp. I would recommend moving as much out as possible. If you're uninsurable, you have a totally different set of challenges and choices ahead of you.
yeah, and take that as an urgent calling. Like, if you are not uninsurable yet, you will be one day. You will with certainty become uninsurable one day, and so deal with that now. And I always just kind of laugh, like we were talking about LinkedIn and the comments and stuff. Well, I don't really I don't engage much, but just seeing the comments on our last video and people are like, yeah, but this still requires you to buy whole life. Sad face. I'm like, how I'm kind of bummed for your clients. Like, you're a CFP and you don't understand life insurance. I know your world because I've gone through the CFP course. I know your world. Like, I can make the same cases you can make, but you can't explain life insurance inside and out. And if you can't do that, I think you're failing, because I know what the CFP course, I know what these exams cover, and it gives you a little, like, a little palette, little taster of life insurance and the role. It's like a basic breakdown of whole life versus term versus IUL. You know enough to like steer into one of those major three baskets, and that's it. You don't know the ins and outs. And if you take away one thing from this, I mean, this shouldn't be the primary takeaway, but there is such a phenomenal depth to whole life and its role in a financial strategy that to not have it and to just kind of be like, oh, it's whole life, and so therefore it's whole life, therefore anything after that, to me, disqualifies you from being able to give comprehensive financial advice. It's so, I don't engage with that, because who cares? It's like, I'm not going to sway you on a LinkedIn comment, whatever. I don't care, but I do kind of care about your clients, because we have these situations where, being in the military, being in the aviation community, like, we collectively in military aviation, I would say, as a subset, know more people that die young than the average person not in military aviation. It's not like planes aren't just falling out of the sky, but I'm racking up the number of names I know that are no longer here. And so things happen, and if you don't have this planning in place and you just write off whole life because your financial advisor said, like, it's just it's so frustrating to me. But if you're listening to this, if you're still here with us at an hour and a half, and of course we failed in our initial goal of, like, keeping
45-minute goal, right? 45-minute goal. But I know, I just started a whole new dialogue. But so yeah, I feel bad for the people whose advisors don't even at least show them whole life. If you're explained it and still reject it, awesome. Fiduciary standard met, ethical and clean. I straddle both worlds. 20 years on Wall Street, chief investment officer. Retain my licenses and will be going back into wealth management again. I took a 4-year pause just to master life insurance because I owed it to my clients, actually, and my clients told me I owed it to them. Right? It's so funny. This is where the
your
bond
high net worth clients demanded that
my
you
billionaires were
become an
like, "Go
expert.
learn this, dude. Go learn this." And I was like, "Fine, you're right." Put on the bond proxy, and then we have to wrap this up. But I pulled up on this screen the AGG, the Barclays Ag, right? It's the broadest measure of the bond market. The Ag is taxable, life insurance isn't. Okay, Hans, what does life insurance typically return after tax? Whole dividend paying whole life.
What are you saying after tax?
What's its return? Don't worry about adjusting it up. Adjust it for what you know. What's the IRR
4 to
typically?
5% internal.
Okay,
4 to
great.
5%
So let's say
internal rate.
4.5. Everybody, for us, 4.5. Okay, ready. In 2016, the Barclays Ag returned 2.55. Is that higher or lower than 5? 4.5.
It is lower and taxable.
And taxable.
Or
In
are you saying
2017, we're doing the next 10 years. No, Ag is pre-tax and life insurance is post-tax. In 2017, the Ag returned 3.4. Is that higher or lower?
that is lower and taxable?
In 2018, the Barclays Ag returned 0.13.
That's
Higher or lower?
after tax, that's a negative.
Yeah. In 2019, the ag returned 8.65. So it beat it. Then you adjust it for taxes. It's still ahead a little bit. 2020, the ag returned 7.5 pre-tax. After tax, it's almost a push. But let's say it beats it. So 2 out of 5 years, the ag is ahead. 2021, the ag index was minus 1.61. What was life insurance? 4.5.
4.5.
In 2022, the ag was down minus 12.99, so minus 13%. Is that lower or higher than 4.5%?
2022 is a year that shattered a lot of financial. It should have been a wake up call for the CFP industry, in my opinion.
2023, the ag is 5.3.
What did you call it? Like a convergence of negative?
It's cross asset correlation convergence is really what a bear market is. It's when there's nowhere to hide, when everything goes down. And that's why I said whole life is so interesting to me as a markets guy. I'm a markets guy first. I have an ability to talk about connected items, and that's where I'm good. I don't have your depth of IBC, right? And so it's interesting so let's just quickly finish the analysis. 2023, the ag was 5.3 after taxes behind life insurance. 2024, the ag was 1.3 behind life insurance. 2025, 7.1, a little bit ahead. So 3 out of 10 years, it was a little ahead. 9 out of 10 years, when adjusted for taxes, it was behind. The cumulative 10-year return, I don't have this on this chart, but it's about 1.2%. So you want to make 1.2% taxable or 5% tax-free.
Yeah.
End of dialogue.
And your bond portfolio doesn't multiply into many times over tax-free for your children.
Yeah. Oh, here it is. The 10-year index 1.58, 15-year 2.21. Morningstar.com for people who want to know the reference, right? So the 15-year return of the Barclays Ag 2.21. Okay.
Yeah.
Fine. That's it. That's the end of dialogue. Mic drop. And then to your point, what does whole life do? Staying power from our last episode, estate planning. From today's episode, apocalyptic optionality for estate planning. The death benefit should pay your estate taxes, even if you keep it all in your estate. So forget any esoteric planning. You're a keep it simple person. You're worth $100 million. You can keep it all in your estate. Knowing you're going to give half up, and your life insurance will cover that half. You're totally cool with that. That's a good problem to have either way. But your plan gets effed when you don't have any life insurance, either in your name or out of your name. So how does IBC, the core question you wanted to tackle today? And we are wrapping up. I actually have a call, so I purposely didn't leave ourselves 7 hours to record. If you have IBC, you've created more options for you. You can move the policy out once it's seasoned, ideally when the dividends can cover the premium, right? When you can do dividends to offset or dividends to reduce, depending. There's a slight difference there that most people don't understand, actually. Or you can keep it in your estate and say, I want to stay illiquid. I have a closely family-held business, and I still want to do IBC. At least I'm manufacturing a terminal cash flow, so no one in my family is a forced seller. That works too. It's more efficient to move most of it out of your state. If you make the decision to move it out of your state, that likely means you have heirs, in which case your very next move is to start buying life insurance on the kids as much as you can get your hands on. When they're of age, 50, 55, 60, boom, you move that out of their estates, and now the money keeps getting a step up, and the liquidity keeps getting manufactured. Uncle Sam still gets his pound of flesh. He's getting it either way. Do you want to sell an asset to give it to him, or do you want the life insurance to give it to him? By the way, that's why the hot swapping doesn't matter, because Uncle Sam's getting his money either way.
Yeah. Amazing. I love it. All right. For the sake of everyone listening, we will wrap this up. We got a couple more to do, and I'm excited about those. I could talk about this all day, and I think I think this is going to provide a lot of value, and I hope that you learned a little bit about estate planning, some of the basics, and then also I hope you were tantalized enough to realize, hey, there's way more to this that I should look into. I owe it to myself and my family and those future generations to get this figured out now, particularly while you're still insurable. So with that, anything else, Ro?
That's it. Thanks for having me on, and hope everybody learned something. I agree. That's what I like to do, is explain things. So thanks, Hans.
All right. Sounds good. All right, everybody. Thanks for sticking with us for an hour and a half. Hour 38 minutes. Well, maybe next time will be shorter, but probably not.
All right. Thanks.
All right.
Thanks for listening to Remnant Finance. If you found any value at all in this episode, please subscribe, leave a review, and share it with a friend.
Remember, true financial freedom comes from taking control of your personal economy and breaking free from the status quo. So stop being a passenger in your family's financial future.
Boldly take back control of your wealth. Until next time,
this is Brian and Hans signing off.